Hello friends, I welcome you all to this session of Indian Law of Evidence, and today we are going to discuss the expert opinion, and this is covered under section 45 to section 51 of Indian Evidence Act. So as usual, let us have a brief overview as to what all we are going to deal in this session. So first we will be discussing as who is an expert. Then we will discuss subject on which expert opinion can be given. What are the broad subjects on which expert opinion can be given under Indian Evidence Act. Then we will see what is the evidentiary value of the expert opinion. Is the court bound by it, or does the court have any discretion as far as expert opinion is concerned? Then modes of proving handwriting, how handwriting is to be proved or can be proved in the court of law, and then opinion on relationship as given under section 50 of Indian Evidence Act. So let's begin. So first of all, we will see section 45. So section 45 provides that the opinion of person specially skilled on points of foreign law, science, art, or question as to identity of handwriting or finger impression are relevant facts. Such persons are called experts. So section 45 basically makes expert opinion relevant, and it does two things. One, it says who is an expert, and another, it says on what topics or on what subject can expert opinion be given. So let us analyze the first part, that who is an expert. So section 45 says that person specially skilled. So who is a person who is specially skilled? Now there are two ways through which a person can be specially skilled. One is that he can be by training, that is by education, by information, by knowledge. And another is by experience, that a person gains skill in certain thing if he is experienced in it. So a person is an expert who by his training and experience has acquired the ability to express an opinion which an ordinary witness does not possess. So in Balkrishna Das Agrawal versus Radha Devi and others, it was held that an expert is a person who by training and experience has acquired the ability to express an opinion which an ordinary witness does not possess. So if an ordinary witness does not possess that ability, and that ability is gained by a person because of his training or because of his experience, then he is a person who is specially skilled and he can be called an expert. Now, another question is that is professional or formal qualification necessary for a person to be called expert? That whether degree in a particular thing, whether diploma in a particular thing is required for him to be called as an expert. Then that was made clear in Abdul Rahman versus State of Mysore. In it, it was held that no formal qualification, no formal degree, no formal education is required for a person to be called an expert. He can be he can be totally illiterate, yet if he is experienced in it, he is an expert as per Indian Evidence Act. So the opinion of professional goldsmith as to purity of gold in question was held to be relevant as opinion of an expert, though he had no formal qualification. So when the question is whether the as to the purity of gold, and the goldsmith has no formal degree, has no formal qualification, yet through experience he is giving his opinion on it, then his opinion will be called expert opinion. So that is what is first part of section 45 as to who is an expert. Now, another thing is that on what points expert opinion can be given, on what subject expert opinion can be given. Now, that is expressed by the second part of section 45, and it makes out 5 topics or 5 subjects on which an expert opinion can be given. So, expert opinion can be given on foreign law, on matter of science, on question of art, identity of handwriting, and finger impression. Now, mind you, friends, the word here is foreign law. It's not law. It's not Indian law. Rather, it is foreign law. This is very important, and therefore, an expert opinion on an Indian law will not be admissible or will not be relevant under Section 45 of Indian Evidence Act. Then, on matter of science, on question of art, identity of handwriting, and finger impression. So these are the 5 subjects on which expert opinion can be given as per section 45 of Indian Evidence Act. Now, what is the principle, the main principle behind this opinion of expert being made admissible under section 45? So that is the principle of necessity. That is, where the question involved is beyond the range of common experience. That is, an ordinary witness does not possess that qualification, that experience to express his opinion on it. At that time, because of this principle of necessity, the expert opinion becomes admissible or relevant. So, where question involved is beyond the range of common experience, or where special study of subject, special training, or skill is needed, expert opinion is called for. So, why an expert evidence or expert opinion is made admissible? Because of principle of necessity. Because the things are beyond the range of common experience. Because an ordinary witness does not possess that ability to express his opinion on that point. Now, what is the expert opinion binding on court? Then the question is that no, expert opinion is not binding on court. It will be appreciated and accepted only if found trustworthy. So the court is not bound by the expert opinion. Now, science and arts, as we saw that foreign law, it's foreign law and not Indian law. Then on matter of science, if we say, then these are things where by naked eye, by our normal experience, we cannot analyze it. For example, DNA test. For example, ballistic expert. For example, doctor's opinion as to age, time of death, cause of death, that is the post-mortem report. All these will fall within the uh, domain of expert opinion. Then, identity of handwriting or finger impression. Now, a point that is a finger evidence on finger impression or handwriting, how can be that proved? So that can be proved by the statement of person concerned under section 17. If the person who has given the or whose finger impression is there, he himself states that yes, it is his finger impression, that he has put his thumb impression there, then by section 17 it will be admissible. By opinion of expert, if an expert through his special knowledge he proves that yes, this particular thumb impression or finger impression belongs to that particular person, then the section 45 it can be proved. Or by evidence of eyewitness, if the person who has seen that person, other person, putting his impression on it, thumb impression on it, then that will also be a relevant fact as far as finger impression is concerned. So finger impression can be evidence of finger impression can be given by statement of person concerned, by opinion of expert, or by evidence of eyewitness. So similarly, a point on foreign law, as I told you, it's not Indian law or law alone, it's foreign law. So a point on foreign law can be proved by, how can it be proved? So as we have studied in section 38, it can be proved by direct reference to books printed or published under the authority of foreign government, or by the ruling of the court of that particular government. If you remember, I gave the example of Poland, that if a particular law is there or not in Poland, then that can be proved by either of the two methods. By a book that is published by the government of Poland on that law, or by the ruling of the court of Poland on that particular law. So section 38 makes that relevant, and section 45 says that even an expert opinion, the person who is expert on that law, on Polish law, so that will also be relevant. So a point of foreign law can be proved by direct reference to books or rulings of the court of the foreign government as given in the section 38, or by opinion of an expert under section 45. Now, we will see another thing, evidentiary value of expert opinion. That is, what is the evidentiary value of expert opinion? So, in S. Gopal Reddy versus State of Andhra Pradesh, it was held that expert opinion is a weak type of evidence. That is, it is not conclusive, and it is not safe to rely on it without seeking independent or reliable corroboration. So this is very important, that first, as far as evidentiary value of expert opinion is concerned, two things are very important. One, that it is not binding on court, it is discretionary on court. And second, that it is a weak type of evidence. It is a weak evidence. That is, the court should not normally rely on it and should seek corroboration of it. So that was also held in S. Gopala Reddy versus State of Andhra Pradesh. Now in Darshan Singh versus State of Haryana, a very important thing was laid down as far as evidentiary value of expert opinion is concerned. So the Supreme Court held that where there is inconsistency between eyewitness on point how injury was caused and evidence of doctor, the evidence of doctor cannot override the unimpeachable testimony of eyewitness. So when the question is how a particular injury was caused, and there is an eyewitness who is trustworthy, and he gives certain opinion. So he says that it was done by blade, and there is a doctor who says that this injury was caused because of gun or pistol or firing. Then if this person or eyewitness is trustworthy, then his evidence will be taken and not that of doctor, though doctor is an expert in that. So that was held in Darshan Singh versus State of Haryana. Next is section 45A, which is opinion of examiner of electronic evidence. So section 45A provides that when the court has to form an opinion as to any matter relating to an information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of examiner of electronic evidence is relevant fact. So where the question is regarding the information stored or contained in any computer or electronic or digital form, that time the opinion of examiner of electronic evidence will be relevant as expert opinion. So for the purpose of this section, an examiner of electronic evidence shall be an expert. Next is section 46, that is facts bearing upon experts. So section 46 provides that facts not otherwise relevant are relevant if they support or are inconsistent with the opinion of expert when the opinions are relevant. So what section 46 says is that suppose there is a fact, and on this fact there is an opinion of expert which is made relevant as expert opinion. Now this is the fact in issue, and based on fact in issue there is an opinion, and that opinion is given by an expert, and therefore it is an expert opinion, and therefore under section 45 this becomes relevant. Now anything which is in which supports it, anything which supports this expert evidence or expert opinion, or anything which is inconsistent with this expert opinion, now they are also made relevant under section 46 of Indian Evidence Act. So section 46 is one step ahead or one step more of section 45, that when an expert, based on in fact in issue, an expert opinion is relevant, then in that case any fact which supports the expert opinion or which is inconsistent with the expert opinion also becomes relevant. Now there is an illustration based on Fox versus Chad. In this, the question is whether an obstruction to harbor is caused by certain seawall. So this is a seawall. If you see, seawall is a artificial stone foundation on which the sea. This is the waves of the sea. The waves of the sea are broken so that they do not harm anything which is inside the harbor. So these are also the sea walls. These are the waves which are coming, and waves are broken down through this stone foundation or laying down this stone so that the ships or the boats which are inside the harbors are not harmed by these waves. So question is whether an obstruction to harbor is caused by certain seawall. So whether this certain seawall is causing an obstruction to this harbor. The fact that other harbors similarly situated in other respects, but there was no such seawall, began to be obstructed at some time are relevant. So other harbors where this seawall was not there, they also were harmed because of it, and begin to be obstructed at the same time, then that becomes relevant because it is in support of this expert opinion. Next is section 47. Sorry. Now section 47 says that opinion on handwriting when relevant. That is how, as we saw under section 45, that opinion on handwriting has also been made relevant. So what section 47 says is that when court has to determine a question whether a document is written or signed by certain person, that whether certain person has signed it or written the particular document, the court can admit the opinion of a person who is acquainted with that person's handwriting. So when there is a suppose a handwriting and the question is whether this person has written it or signed it, then the opinion of a person who is acquainted with it, acquainted with the handwriting of this person, will be relevant. Then the explanation provides as to who all can be called to be acquainted person. So the explanation to section 47 states that person who are considered to be acquainted with another's handwriting are, so three kinds of persons have been considered under section 47 to be acquainted with this person's handwriting. Now who are they? Who have seen that person write. So a person who has seen, suppose he is seeing this person writing it, then he is a person who is acquainted with it. Who has received documents written by that person in answer to documents written by himself or under his authority and addressed to that person. So suppose he has written certain document to him and on that, based on that document, he has written some answer back to him, then this person can be called to be a person who is acquainted with the handwriting. And third is, who has in ordinary course of business received a document written by person, or such documents are habitually submitted to him. So if his reports are habitually submitted to him, suppose he is his official senior, then in that case also he will be considered a person who is acquainted with the handwriting of, if he is A, then A. So section 47, what it says is that if it is to be proved that whether this particular handwriting is that of this person or not, then how can it be proved? It can be proved by the person who is acquainted with this person's handwriting. And who is a person acquainted? There are three types of person: one who has seen him, one who receives document from him in reply to his documents, or a person who receives his document in ordinary course of business. Now, how do we prove, or what are the modes of proving handwriting? So there are four modes of proving handwriting as given in the Indian Evidence Act. So one is that by evidence of the writer himself. So if the person who is writing, he himself admits, this is admission. So if he himself admits that this, yes, this is my handwriting, then it may be admissible. Then by opinion of expert in the section 45. So if a person who is expert in handwriting, as it is seen, so if he says that yes, it is his handwriting, then that is also that may also be admissible. Then section 47 says that a person who is acquainted with the handwriting of the person, so if he has seen him writing, or if he receives the document in reply to his own letter, or if the person habitually receives letter in ordinary course of business from him, then he is a person who is acquainted, and the 47 he can prove that is his handwriting. Or by the court comparing the handwriting under section 73, or the court can also compare the handwriting from his previous handwriting or subsequent handwriting, and that also handwriting can be proved. So these are the four methods through which handwriting can be proved. Now, in Fakhruddin versus State of MP, it was held that handwriting may be proved by the evidence of witness in whose presence the writing was done, and this would be a direct evidence, and it is available. If it is available, evidence of any other kind of is rendered unnecessary. So if a person who is, he has seen him writing, then he is a person who is acquainted with the handwriting, and then under section 47 it will be taken as a direct evidence as the as per section 47 also, and this was reiterated in Fakhruddin versus State of MP. Now section 47. Section 47 states opinion as to digital signature when relevant. So section 47 provides that when court has to form an opinion as to the digital signature of any person, the opinion of certifying authority which has issued the digital signature certificate is relevant fact. So whether a particular digital signature belongs to a particular person or not, suppose this is the question, then the person or the authority who have issued this digital signature to him, or who had given the digital signature to him, his opinion is made relevant under section 47A. Next is section 48. Opinion as to existence of rights or customs when relevant under section 48. Section 48 provides that when the court has to form an opinion as to the existence of any general custom or right, the opinion as to existence of such custom or right, the person who would be likely to know its existence if it existed are relevant. So the question is that whether a particular custom or right exists or does not exist. then opinion of the person who is likely to know about its existence is relevant. But mind you, friends, these are general customs or rights. So, explanation to section 48 provides that general custom or rights include customs or rights common to any considerable class of person, not particular. So, section 48 makes where the court has to decide whether a particular right or custom exists or not. Then, a person who is likely to know about its existence. Suppose he's a very old person and he has been through those process, then it is that he may be likely to know about this particular custom or right. Then his evidence will be relevant. But mind you, it should not be particular custom or right. It should be general custom or right. So illustration is attached to it. Illustration: the right of villager of a particular village to use the water of a particular well is a general right within the meaning of this section. So whether there is a when there is a well and whether villagers have general right to use this, or whether the villagers have right to use this well or not, is a general custom or right. Now, how this is different from section 13. So section 13 deals with all kinds of rights or customs. So under section 13, any transaction where that right has been created or have been denied are made relevant, or any particular instance have been made relevant. But under section 13, all kinds of right, whether public or private, is dealt with. But under section 48, as it has been specifically mentioned in the explanation itself, that only general customs or rights are made relevant. Now, section 49. Section 49 is opinion as to usage, tenets, etc. when relevant. So section 49 makes opinion of such person relevant who have special means of knowledge regarding the usage, tenets of any body of men or family, the constitution and government of any religious or charitable foundation, the meaning of words or terms used in particular district or by particular class of person. So whether where the question is that what is the usage or what is the tenants, then any person who has special knowledge about it is relevant. Where the question is that of a charitable foundation or religious foundation, what is the constitution, what is the government, how it is governed itself, then the person who has having, suppose there is a priest who is in that temple for last 40 years, 50 years, so he will be having a special means of knowledge regarding it. His opinion is made relevant. Then what is the meaning of a particular word or a particular term? For example, if the word is rose namcha, then what is the meaning of that particular word or that particular term? Then a person who is in police may have a special, because he has been in that profession, so he has a special means of knowledge of regarding it. So this is made relevant under section 49. Now, under section 50, opinion on relationship when relevant. So section 50 makes relevant the opinion of person expressed by his conduct, who as a member of the family or otherwise has special means of knowledge as to relationship of one person to another, provided that such persons shall not be sufficient to prove a marriage in proceeding under Indian Divorce Act or in prosecution of 494 under the Indian Penal Code. Now, under section 50, the opinion must have been expressed by conduct and not merely by words or statements. So, where the question is that what is the relationship between, suppose, A and B. Now, then the opinion of C, suppose A and B are living together for a long time, and C is a very much every week or every 2 to 3 days he regularly visits the house of A and B. Then, as he has got special means of knowledge of the relationship between A and B, and that is not expressed by the words of A and B, but through their conduct as to how they receive C, what they talk among themselves, then this becomes relevant. That then the statement of C becomes relevant as to what was the relationship between A and B, whether they were um, mother and son, where they were brother and sisters, where they were husband or wife. So that becomes relevant under section 50, opinion of C. So opinion of a person who has a special means of knowledge of what is the relationship between two persons, and mind you friend, that opinion should not be based on what was the statement of A or what was the statement of B, but through the conduct of the person concerned is made relevant under section 50. So, and here also it is made clear that marriage between two persons, that the two persons are husband and wife, or is not proved conclusively under it, or will not be sufficient for certain provisions of Indian Penal Code and Indian Divorce Act. So the question is whether A and B were married. The fact that they were usually received and treated by their friends as husband and wife is relevant. So what is the relationship between, say, this boy and this girl? Then this person who regularly visited their house, and he was received by them as husband and wife through their conduct, not a statement. Through their conduct will be relevant under section 50. Now, section 51 is one step ahead of section 50. So, grounds of opinion relevant. Section 51 provides that whenever opinion of any living person is relevant, the grounds on which such opinion is based is also relevant. So suppose A has given certain, under section 45 or under section 50 or under section 49, A has expressed certain opinion. Then there is a fact in issue, and based on this fact, A is an expert, or A has special means of knowledge, and he has expressed certain opinion. Then under this 45, 50 or 51, this becomes relevant. Now, when this becomes relevant, the basis on which it is said also becomes relevant, or the grounds on which this opinion was expressed also becomes relevant. So that is what is section 51. That's all about expert evidence, friends. Let's have a quick review as to what all we did regarding expert opinion. So first, section 45, which says that opinion of person especially skilled on point of foreign law, matter of science, question of art, identity of handwriting, and finger impression are relevant. Now, who is an expert? Expert is a person who, by his training or experience, has acquired a skill which an ordinary witness does not possess. However, there is no formal qualification required, and the principle on which it is based is principle of necessity, because these things are beyond the range of common experience. However, it is not binding on court of law. Then we saw that another thing is that it is as far as evidentiary value of expert opinion is concerned, it is not binding. It is a weak type of evidence, and corroboration may be required for it. Then under section 45A, when the matter relates to that of digital matter or digital evidence, then the evidence of or opinion of examiner of electronic evidence is an expert. Then the section 46, when an evidence is an expert opinion and it becomes relevant, then anything which supports it or which contradicts it are also relevant. Under section 47, opinion as to handwriting of a person who is acquainted, when the question is whether the handwriting is that of a particular person or not, then in that case, the opinion of a person who is acquainted with the handwriting of this person is relevant. And who is a person acquainted? Who has seen him writing it, who have received document written by him, or who in ordinary course of business receives document from him. Then we saw section 47A, that where the question is that whether this particular digital signature belongs to this person or not. Then the person or the authority who have issued this digital signature or certifying authority, opinion of that will be relevant. Then section 48 says that where the question is that where a general custom or right exists or not, then opinion of a person who is likely to know of its existence is or are relevant. Then the section 49, where the question is that whether particular usage or tenant exists or not, then the person who is having a special means of knowledge regarding it is relevant. Where the question is regarding constitution and government of any religious or charitable foundation, then again a person having a special means of knowledge regarding it is relevant. And what is the meaning of a particular word or a particular term in a particular place, then the person who has special means of knowledge is again relevant. Then the section 50, where the question is that what is the relationship between the two persons, then a person who have special means of knowing it and through their conduct, then his opinion is relevant. Then section 51 says that when an opinion of a living person is relevant, then the ground on which such opinions are based is also relevant. Thank you, friends.